All right. I am tempting fate this morning. The guinea fowl are in the front yard. Hopefully they'll stay in the front yard for a while. We're going to start with Decastro. Ooh, lots of stuff has happened. So the first thing is the motion to recuse. First thing that happened that I'm going to talk about was the response to the motion to recuse. And the response to the motion to recuse is exactly what you would expect it to be. You can't just say, well, they ruled against me and hope to win on that. And that's really what Decastro was saying. Decastro's entire motion was that, well, the judge ruled against me, and so therefore the judge must be biased because, well, that's the only reason why you could rule against me. So that's their obvious response. That's how they responded. And then Chili comes back with a reply. Now Chili's reply is a little bit odd. It's a bit of a swing and a miss because what Chili argues is that technically, if there is, I do like this part is really nice though. The nope defense part. Where is that at? Basically using the nope defense. I could tell that Chili has been watching me. Or no, I didn't come up with the nope defense. Maybe he's been watching someone else. I shouldn't take credit for the nope defense. But what he's trying to argue is that if the judge displays a deep-seated and unequivocal antagonism that would render fair judgment impossible, then yes, that would also be bias. The problem is that the case on point, that the example that the court goes to is an example where it's either during or slightly after the First World War. A judge in a case said essentially that it would take a very judicious person to not be biased against Germans because they were obviously I don't remember exactly, but it's like they're obviously bad people, and they sided with Germany during World War I. So you can't trust American citizens of German descent. And this is after World War I, so there's no allegations that these were the terrible N words, not the black N words, but the white nationalist N words, I guess. So the issue is that Chili can't point to anything like that. That Chili can't point to the judge saying something that clearly displays a bias against Chili. All Chili can point at was that the judge ruled against him, and that's what the city of LVMPD pointed to. That this is all your evidence. Chili saying, well, there's this other factor, doesn't change anything because Chili did not raise in his moving paper any bias that is readily apparent beyond the judge ruled against you. So that's going nowhere, and it's going nowhere very fast. The judge will deny that particular motion. So then there's a new motion to dismiss the amended complaint. There are two things of note in here. So this is the first thing is that they point out that a lot of the issues that Chili raised were already dismissed with prejudice. So you can't re-raise them. And the second issue that they raise is that the video from the officer's camera, which Chili references in his complaint, and which the defendants have provided to the court, shows that there was no excessive force. Now, I don't know if that's going to be the way the court's going to go. Video can show you what happened, but it can't necessarily show you what didn't happen. Any particular point where there was not a body camera focused on Chili's nutsack may or may not show Chili getting punched in the nuts. You know what I'm saying? Like, is there any point in the entire collection of body cam footage? Well, first of all, will the court allow it? Second of all, if the court does allow it as part of the as being integrated into the complaint, integrated by reference into the complaint, incorporated by reference into the complaint. That's the word I'm looking for. Then it would be a motion to dismiss, but they're also asking for a motion for summary judgment based on it. So either way, the court will be able to consider it. But the question is, will that collection of body cam footage show Chili's nutsack and or the placement of the officers for the entire period of Chili's detention in such a manner that would preclude Chili ever getting punched in the nuts? It might not. I haven't watched any of that body cam footage, let alone all of it, so I don't know what it will show. But that's their hope. And the other issue is that they're not, I don't believe, contesting the squozing of the ulnar nerve. I don't believe they're contesting that. So, in theory, that would be a question of law for the court to determine whether or not squeezing someone's ulnar nerve to get a little bit of pain compliance, if that is unreasonable force. And my best guess is it would not be unreasonable force. So that's, I think, all that's really of any interest in this particular case. Chili did file a this just confirmed the ruling. There's 14 days after a Court of Appeals decision to ask for a panel or seek a writ of certiorari. And then after that 14-day period, then the court has 7 days to basically send the lower court a notice that the opinion has been affirmed, that it's a good opinion. The appellate court decision has been affirmed. So that's what's going on with him. So nothing interesting, really. Springer versus 7th Judicial District Court. I haven't looked at this one yet, so let's see what's going on. So the motion to dismiss was moot. We knew that because they amended it. There it is. There's a reply to the second motion for temporary restraining order. Sure, let's look at it. Let's see if there's anything of interest in here. So the defendants are stupid. They don't understand the law. We're going to look at committee commentary, which, okay, committee commentary is fun and everything. So he's arguing that what the defendants were trying to do was they were trying to get Springer on charges of contempt, criminal contempt, that the DA declined to prosecute, and that now there is no reason for a younger abstention or anything like that. Rooker Feldman. There's one other potential abstention reason. So that's what they're arguing there. Defendants mischaracterize factual averments or resort to outright falsities in their response. Plaintiff never harassed or threatened. Again, I think we've covered that. I think the court did say that yes, that James had harassed. I don't know if the court said that they threatened, but definitely harassed. Then it would go on to quote James Madison, who doesn't really matter. So again, I think the issue is that There is nothing going on that the court needs to issue injunctive relief on. For all the things the court has already denied injunctive relief on, for all the facts and issues that were already presented to the court, and the court already looked at and said, no, those I'm not interested in those. I'm not going to issue any injunctive relief at this point based on those. Those are going to be done. The court's going to say, no, I already ruled on this. You don't get a second bite or a third bite at the apple since you already have an appeal pending. As far as the new issue, the issue of the post-complaint allegation that the 7th Judicial District Court has attempted to have Springer's content taken down, that one piece of content that was taken down for a spam identification for a link that went to a Google search page that was resolved when Springer appealed it. That one I don't think the court's going to issue any injunctive relief on either, because first of all, it's next to impossible to show that the 7th Judicial District Court had anything to do with it. There's no reason to suspect the 7th Judicial District Court had anything to do with it. And if the 7th Judicial District Court had power over YouTube to make YouTube take down Springer's content, then it begs the question of why, after an appeal, Springer's content was restored. So it doesn't make a lot of sense. I don't foresee the court granting any injunctive relief based on the foregoing. There's a motion to dismiss the amended complaint. I don't really care about it. I just don't really care about it. I'm not going to cover it today. I'm on a bit of a time crunch deadline, so you'll have to forgive me. There's a status conference. Interesting. On Wednesday at 10 a.m. Interesting. I wonder what the court's going to want to talk about. This isn't going to be on the motion to dismiss the amended complaint. This might be on the this might be on discovery. I don't know exactly, but we'll find out. It's going to be stupid. I don't want to do it. I'm on a bit of a time crunch. 27 pages. All right. Let's see. So they're alleging Twickball that it wasn't factually sufficient. I just don't care enough. Anyway, what I really kind of wanted to talk about today was there's been ongoing debate. There's been ongoing debate in my Discord with Rogue Nation. Rogue Nation has apparently been charged with violations of, let's look at it. Let's look at it. Is it Open Docs? Here we go. Because I find this a bit more interesting and topical to me than the slap fight that's going on in Springer's case currently. If either side had competent attorneys, Springer would be much more interesting, because there are genuine issues in Springer versus 7th Judicial District Court that can and should be raised, and I don't think either side is really addressing them very well. It's just very frustrating to me, and I don't want to do it. So these are charges in the Middle District of Florida against Metz, aka Major Lee Awesome. He's being charged with 6 counts. I'm going to cover Earl's appeal. Earl's appeal is very interesting to me, but Earl's appeal got kicked out. Not his appeal, but I think we're in January. So let's actually take a detour and talk about Earl's appeal real quick. The defense, or the state, I should say, yeah, Monday, January 8th is now when the state's reply or opposition brief is due. So I normally don't really care about extensions and things like that, extensions of time, because attorneys do get busy. These memorandums, appellate memorandums, I have done a few. I've done probably 4 or 5. I could remember 3. I might have done more. But they take a long time. They take a whole long time. You got to do a ton of research. It's because not only do you have to re-argue the underlying case, but you have to also argue the particular kind of review the court's going to do, and then you have to analyze that level of review. So if it's a substantial evidence, or if it's an abuse of discretion, or whatever kind of review it is, you have to go through all of the steps. So it's a lot of work. It's 2 layers at least of writing, and you can't leave anything out, anything up to doubt. It takes a long time. So I normally don't object at all to an attorney asking for an extension of time, or even 2 extensions of time to do a appellate brief. In this case, though, with the strength of the arguments raised in Earl's brief, in Earl's attorney's brief, and in the fact that Earl is currently confined, it really irritates me that the state, their initial briefing date was, I believe, sometime like September 8th. I think September was when it was originally due. And so they've dragged this out for October, November, December. It'll be an additional 4 months that Earl's, if they actually get their opposition filed in January, which is questionable, but they've dragged this out for 4 months. Now, for those of you who are giving Earl's attorney a lot of shit for his request for extension of time, that's his client, and he needs to do it right. Great. But 4 months of extensions. And you got to remember that Earl's attorney was given basically, this is your last shot. You need to do it this time. If I remember correctly, I think he was given this, you don't get any more extensions. Merva's going to play hockey defense. Anyway, it just bothers me. It bothers me that I'm not saying he is innocent, but he is a potentially innocent man. And I don't like him. I don't fucking like the man at all. If he shows up at my doorstep, I will shoot him. I'm telling you right now, he has threatened my family. If he shows up at my door, I will shoot him. I consider him a threat to my safety and my family's safety. He's a felon with a record of violent assault and a penchant for firearms. He is a threat to my safety. I don't like him, but he's potentially innocent. And I don't like potentially innocent people being locked up and having the state has a higher burden. The state should not be allowed to drag it out for like 4 or 5 months. So January 8th, it should be an opposition filed by the state. Earl's attorney would then have the opportunity to file a reply brief to the appellate court, and then at some point after that, there should be oral arguments, and then we'll have a decision from the Court of Appeals. So that's kind of the way this should play out. If at the end of this, if the state can't actually mount a good justification of why it raised the Mormonism, why it raised the fact that, or the allegation that Earl didn't allow his half black stepson or whatever it was in the house, if they can't give a good justification for that, and they've drugged this out for an additional 4 months, Earl might actually have grounds for relief, for monetary relief against the state. Just so you guys are aware. I mean, I'm not saying that he will. I'm not saying that he does. I'm saying that he might have grounds for relief. Isn't there a right for speed trial? No. Generally speaking, well, I guess he could have filed a habeas in federal, but I don't. He didn't do that. And habeas would essentially require them to do things a little bit faster, but they didn't do that. So anyway, let's go back to Rogue Nation. There's two charges that he's facing, or well, there's two types of charges he's facing. So here's 41 CFR 102-74.385. He failed to comply with official signs of a prohibitory, regulatory, and directory nature. He hasn't really been arguing on that. But the other charge, or there's 6 charges that he's implicated in. But the other regulation that he is charged with violating is 41 CFR 102-74.420. And he doesn't understand it. And so I would like to go over it to make sure that that we understand it. So the first thing that you need to look at is you start reading the statute, not this part, but you start reading the actual statute from the beginning. And it starts off with, except where security regulations, rules, orders, or directives apply, or a federal court order or rule prohibits it, persons entering in or on federal property may take photographs of. That's a prefatory statement. So the part that, if there is a security regulation that prohibits photography, then you stop, because this rule only applies where there is no security regulation against photography. Now, that doesn't mean that a restriction against photography couldn't be challenged. You could make arguments that it's unconstitutional, but trying to say that this particular chapter allows you to record is dead if there is a security regulation that says you can't record, that you can't photograph. If there's a rule, you're going to say, well, what kind of rule? Well, obviously, it's not a federal rule, because if you look, it says, or a federal court order or rule. So that's going to be a federal court order or a federal rule. So what would it be? It would be an internal rule. It would be the rule of a tenant agency. The next one is order. It's not a federal court order. So it has to be the order either of a state court, which most likely won't apply to a federal tenant, like the Social Security Administration, for example. A state court is not going to have jurisdiction to sue, or not to sue, but jurisdiction over the Social Security Administration to apply an order to it. So what kind of order is it? Well, it's not a federal court order. See how it's federal court order? This is just an order. So what kind of order is it? Could it be the order of some security guard saying, you can't film here? That would be an order. You would be saying, don't film. That's an order. Directive. What kind of directive? Well, this isn't a federal directive. This could be a directive from the head of the agency, from the head of the tenant agency. But it doesn't say that has to be posted or anything like that. If there's any one of these things preventing you from filming, then this whole section doesn't apply. And we haven't even gotten to federal court orders or federal rules. Persons entering in or on federal property may take photographs of. What may they take photographs of? Now notice, this is specific language. What may they take photographs of? It doesn't say they can take photographs in, they may take photographs of. Well, they may take photographs of, I'm assuming that also relates to taking video of, space occupied by a tenant agency for non-commercial purposes, only with the permission of the occupying agency concerned. So they can take photographs of that space if that agency says you can do it. Same thing for commercial purposes. It just has to be written permission of an authorized official. What's the difference? Well, the difference is if you ask real nice and the security guard says, yeah, I don't mind if you take pictures of this specific thing you asked, then you could do it. But if you want to do it for commercial purposes, i.e. like to shoot a film or like a commercial or a commercial film, like something that you're going to put into a movie or something like that, then you would need written permission from an authorized official, an official that has the position in the agency sufficient to allow them to make a decision on when you can film for commercial purposes. And then it goes with and building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. So you can take photographs of, remember see that of is still up there, that of ... or hyphen, I don't know. So they may take photographs of building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. So there's a couple of things that you need to unravel there. Number one, what is news purposes? And it doesn't say you can take photographs in them. It says you can take photographs of them. But what if it's a lobby that is occupied by a tenant agency? So you might have the main in a federal building, that has multiple agencies, where no specific agency's rules, regulations, orders, directives, etc., are going to apply to that community lobby. You can film there for news purposes. What is a news purpose? You going in there just to film isn't a news purpose. If there's nothing newsworthy going on, you're going to have a very hard time telling the court that you're there filming for news purposes. If you're the only one causing a disturbance, you're going to have a hard time justifying to the court that you're filming for news purposes. If there's nothing newsworthy going on, you're not filming for news purposes. The weak sauce kinds of excuses that auditors like to make, that I'm filming for news purposes when there's nothing going on other than the auditor being a jackass, has never been convincing to a court. A court has never bought that argument. I don't expect a court ever will buy that argument because it is a completely shitty argument. But what about lobbies that are in tenant spaces? What if there's a main building lobby and then there is a sub lobby? Like on the left-hand side of the building, there's a Social Security Administration office. And on the right-hand side of the building, there's a state DMV. Each one of those may have its own lobby where you turn off of the main lobby and you go into a waiting area, a holding area, an area that would lead to other offices inside of that tenant occupied space. Would you be able to film in that area for news purposes? Well, maybe, if you have the permission of the tenant agency, because the GSA can't tell another agency what to do in space leased by that other agency. What are you talking about? If spam is intolerable, come to my live chat right now. Let's see. Cock-a-doodle-doo. See what we got going on here. So this fucking idiot is talking about, was Mr. Herring really experiencing a serious medical episode? Really, bro? Really, bro? I'm sorry. Where were we? So the GSA cannot tell a tenant agency what to do in their space. If a tenant agency has rented that space, the GSA cannot tell the tenant agency that tenant agency has to allow you to enter into their lobby that they are leasing and allow you to record. Now, why? How do I know that? Well, because if you go back to the very fucking beginning, this part still fucking applies. That part still applies. So if you go into a tenant space, into a tenant occupied lobby, and you say, well, the GSA says I can film there, they're going to say, well, we have a security regulation, rule, order, or directive that applies to filming in this space. And we don't allow you to film in this space. Well, then that's it. That's all. That's it. That's done. So saying that subsection C allows you to film in any lobby, in any GSA building for news purposes is not true. It is inaccurate. It misstates the regulation. 9 o'clock. It's time for me to go. Thank you for watching. Have a wonderful day.